Hello everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty at iExamBee. In this video, I have come up with a very innovative series that we are going to begin today. But before we start, don't forget to subscribe to our YouTube channel and stay updated with all such kind of beneficial content that we keep on providing at LegalBee. अगर आपकी कोई भी queries हैं, you can write to us at hello@iexambee.com. Or you can also write in the comment section of this video. If you have any doubts or you want us to come up with a video on, we will definitely try to come with a solution. आप इस नंबर पे कॉल करके भी अपने डाउट्स क्लियर कर सकते हैं and you can also visit our website for more guidance. One more thing is that iExam is the only platform that provides mock tests at zero cost. So इसका benefit उठाइए, go and visit the website and check out all the mock tests for whichever examination you are preparing and all the best for your preparation. Start करते हैं हमारे वीडियो के साथ. Landmark judgments. Landmark judgments are very important part of legal current affairs, not only for जुडिशरी एग्जामिनेशंस या फिर जो लोग लिटिगेशन में हैं उनके लिए ही नहीं, बट ऑल्सो फॉर ऑल दोज हु आर प्रिपेयरिंग फॉर अदर एग्जामिनेशंस लाइक यूपीएससी. इन सब एग्जामिनेशंस में जो लीगल करंट अफेयर्स का पार्ट होता है उसमें लैंडमार्क जजमेंट्स बहुत ही इंपॉर्टेंट रोल प्ले करता है. जो लोग कोर्ट में जाते हैं उनके लिए तो है ही, बट नॉट ओनली रेस्ट्रिक्टेड टू दैट. अगर आप कॉम्पिटिटिव एग्जामिनेशंस के लिए प्रिपेयर कर रहे हैं एंड इवन फॉर जुडिशियल थिंकिंग, इफ यू वांट टू बिकम अ जुडिशियल ऑफिसर ऑल्सो, आप में वो जुडिशियल थिंकिंग डेवलप कहाँ से होगी? व्हेन यू रीड मोर एंड मोर जजमेंट्स, यू अंडरस्टैंड द इंटरप्रिटेशन ऑफ लॉ इन अ बेटर मैनर. एंड ऑल्सो जुडिशियल एग्जामिनेशंस में आपको एक जजमेंट राइटिंग का सेक्शन भी होता है दैट इज आस्क्ड इन द मेंस एग्जामिनेशन. सो उसके लिए भी ये आपको बहुत अच्छे से प्रिपेयर करेगा इफ यू आर वेल वर्स्ड विद द रीसेंट अपडेट्स इन द लीगल डोमेन. सो iExamBee हैज कम अप विद दिस इनिशिएटिव. इसके लिए LegalBee को सब्सक्राइब करना ना भूलें एंड स्टे अपडेटेड विद ऑल द 15 days अपडेटेड वीडियोज दैट आई एम गोइंग टू प्रोवाइड यू हियर एट LegalBee. इस वीडियो में हम लोग 1st to 15th of January 2023 के important landmark judgments कवर करने वाले हैं of the Hon'ble Apex Court and also of some of the High Courts. अगर क्योंकि एक और एक important बात यहाँ पे ये है that they are the courts of record. As per constitutional law, courts of record का status दिया गया है High Court and Supreme Court को. The judgments that they are giving, these judgments are having precedentiary value. So you need to have an updated record of all such kind of judgments. So let's start with our first judgment that we are going to see in this year that we got is 2nd of January 2023 को Hon'ble Apex Court ने ये judgment pass किया है. Vivek Narayan Sharma versus Union of India. The area that was discussed in this case was relating to the demonetization of notes that had taken place in the year 2016. इसको challenge किया गया था RBI Act के section 26 के अंडर. RBI का जो एक्ट है, दिस डिसाइड्स द पावर्स दैट आर गिवन टू द RBI टू द सेंट्रल गवर्नमेंट रिलेटिंग टू डीमोनेटाइजेशन. जो गवर्नमेंट ने पॉलिसी पास की थी, इट वाज सब्जेक्टेड टू चैलेंज इन द कोर्ट एंड कोर्ट हैज फाइनली डिसाइडेड इट इन द बिगनिंग ऑफ दिस ईयर and upheld demonetization policy by a 4:1 majority ratio. It was held that the opinion of central board is not binding on the central government, and if a negative opinion is received, then the central government shall resort to a legislative process and not act through a notification. यानी कि यहाँ पर ये जजमेंट में अपहोल्ड तो किया गया है डिमोनेटाइजेशन पॉलिसी को, और ये कहा गया है कि जब सेंट्रल गवर्नमेंट ऐसा कोई डिसीजन लेती है तो सेंट्रल गवर्नमेंट को ओपिनियन लेना होता है सेंट्रल बोर्ड का ऑफ द RBI. एंड अगर सेंट्रल बोर्ड पॉजिटिव डिसीजन नहीं देता है तो इसका मतलब ये नहीं है कि सेंट्रल गवर्नमेंट पास नहीं कर सकती अपना डिसीजन जैसे डीमोनेटाइजेशन को लेकर किया गया, बट द ओनली रिजॉर्ट इज दैट दे हैव टू रिजॉर्ट टू अ लेजिस्लेटिव प्रोसेस फॉर दैट. लॉ मेकिंग प्रोसेस जिस तरीके से होता है, और सिर्फ सिंपल नोटिफिकेशन से काम नहीं चलेगा. So this was a very important landmark judgment that we received in the beginning of this year. So it is notable. अगर आप चाहते हैं आप इस PPT को डाउनलोड कर सकते हो in the comment section of this video. This will definitely help you out a lot as you will have a record of all the judgments with you which are very landmark. इस वीडियो को पॉज करके भी आप इसे नोट डाउन कर सकते हैं. Next is 3rd of January 2023 को the very next day we got a judgment Kaushal Kishore versus State of UP and others. This was also by the Honorable Apex Court. This was relating to hate speech by public functionaries and Article 19 Clause 2 of the Constitution. यानी कि जो फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन है एंड उसके जो रीजनेबल रेस्ट्रिक्शंस हैं, इसके को रिलेशन में हेट स्पीच पर ये जजमेंट बात करता है. प्रोविजन ऑफ लॉ तो हमने देख लिया, बट व्हाट वाज द एक्चुअल रेशियो दैट वी विल सी. Any citizen who is prejudiced by any form of attack as a result of speech or expression through any medium, that can be electronic as well, targeted against him or her by speech which constitutes a hate speech or any species of that, whether such attack or speech is by a public functionary or otherwise, may approach the court of law under criminal and civil statutes and seek appropriate remedies. यानी कि hate speech को हमें किसी भी तरीके से कंट्रोल करना है, ये ऑनरेबल एपेक्स कोर्ट का मानना है, ओपिनियन है. अगर आप इस जजमेंट को पूरी तरीके से पढ़ोगे, यू विल गेट मोर idea on it that public functionaries हो या कोई भी anybody, everybody is subjected to rule of law and they have to and if anybody makes any statement that can be by Twitter, that can be by public speaking, anybody it is subjected to reasonable restrictions. Article 19(1)(a) is subjected to reasonable restrictions. Next, Smriti Debarma versus Prabha Ranjan Debarma. In this particular case, this is actually a civil case and it is, I would say, it is a very interesting case. Supreme Court has observed what, पहले हम वो देखेंगे, then we will go to the provision of law again. In this case, the Honorable Apex Court has observed that the decree of possession cannot be passed in favor of the plaintiff merely because defendants were not able to fully establish that right and interest in the property. यानी कि जो burden of proof है, section 101 and 102 of Indian Evidence Act is attracted over here, that whenever anybody is asserting any right before the court, the burden of proof lies on that particular person. It is not that if the defendant is not able to prove his title, automatically the decision has to be passed in the favor of plaintiff. ऐसा नहीं है. This was held by Honorable Apex Court in this case. The defendants cannot be dispossessed unless the plaintiff has established a better title and rights. क्योंकि possession में उसमें defendants थे. इस case में person whoever is in possession of land has assumed the character as the owner and exercising peaceably the ordinary rights of ownership. He is having a legal right against entire world except the rightful owner. यानी कि जो possessor है land का, उसको एक ऐसा legal character मिल चुका है that he is having ordinary rights of ownership against the entire world except the rightful owner. तो जो rightful owner है उसे ये prove करना होगा that he is entitled to that particular property. And that is not something which the defendant is not able to prove. If he is having weak evidence for that, that does not automatically give favor to the plaintiff. ये बहुत ही important judgment है. I would say it is very landmark in case of civil suits and civil cases and is very important. You must note it down. Next, state represented by the Inspector of Police versus Maridas and another. ये एक बहुत ही इंपॉर्टेंट जजमेंट है क्वॉशिंग ऑफ एफआईआर्स के बारे में. क्रिमिनल लॉ में काफ़ी अच्छा डेवलपमेंट आया है. दिस इज अबाउट hasty decisions by the Hon'ble High Courts that are being done, that has been taken care of by the Apex Court in this particular judgment. The FIR was launched in this particular case. The FIR was launched on 9th of December 2021 and immediately within 4 days it was quashed. The decision of quashing was passed within 4 days. So the observation that was made by Apex Court was that it is the right of the investigation agencies to conduct the investigation and a reasonable time should be given to them for that. 4 days में अगर आप FIR quash कर दोगे, so that is something which is not amounting to proper investigation which is carrying out by the agencies. So investigation should be carried out by the agencies. उनको उतना टाइम मिलना चाहिए. And it is found that the allegations in the FIR do not disclose any cognizable offence at all or the complaint is barred by any law. ये काम किसका है? Investigation agencies का है. So जो inherent power है High Court का 4R82 के अंडर, that is CRPC, that should not increase the scope that much. इसका मतलब actually ये होता है. तो hasty decision हुआ था हाई कोर्ट का, तो इस डिसीजन में सुप्रीम कोर्ट ने कॉग्निजेंस लेकर उसे उस डिसीजन को कैंसिल, उस डिसीजन को डिसमिस किया है, वी कैन से इन दिस पर्टिकुलर केस. Residents Welfare Association and another versus the Union Territory of Chandigarh and others. That is 10th of January 2023 को ये judgment pass हुआ है. Now this is something which is very important area from environmental law point of view. Environmental impact assessment के बारे में अगर हम बात करें, जो बहुत ही recently काफ़ी developing domain है. State of चंडीगढ़ के बारे में ये heritage sites से related एक केस है. यू कैन गो इन टू द फैक्ट्स ऑफ द केस इन डिटेल, बट इसमें जो प्रोविजंस ऑफ लॉ के बारे में डिस्कस किया है, दैट इज डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी, आर्टिकल 49 एंड 51A, that is fundamental duties, clause F and G of the Constitution of India. 49 talks about the protection of monuments and places and objects of national importance. कि उसको आपको ध्यान में रखकर आपका डेवलपमेंट करना है, सस्टेनेबल डेवलपमेंट करना है. एंड 51A fundamental duties, it is talking about our duty to value our heritage sites and improve the natural environment, including forests, lakes, rivers. Sustainable development is there. So whenever you are having any project in hand, the government has a responsibility. The executive, legislature, policy makers at the center, as well as the state levels should take a note of the damage to the environment on account of haphazard developments. So whatever projects are going on, that has to be checked. Environmental impact assessment has to be carried out, that sustainable development is being carried out and a proper balance is struck between protection of environment and sustainable development. ये observe किया है इस particular case में. So again, this is a very important case. The Chief Engineer, Water Resources Department and others versus Ratan India Power Limited through its directors and others. This was another important judgment in the field of contracts. अमाउंट ऑफ कंपनसेशन की यहाँ पे बात की गई है कि अगर कोई कॉन्ट्रैक्ट, कोई एग्रीमेंट एंटर हुआ है, तो उसमें जो अमाउंट ऑफ कंपनसेशन है वो जितना डिटरमाइन किया है, उसमें क्या बाद में चेंजेस हो सकते हैं. सो दिस issue was addressed and the statement of the judge has been taken up over here, that the short question which arises for our consideration is the present case relates to whether a party to a contract is entitled to question the amount of consideration after signing the contract. So the principle of estoppel was applied here. Adverting to the facts of the case, it was held that respondent number 1 is estopped from doing so because the appellant has already in all its communications decided for an amount already that amount was reserved for some irrigational purposes. ये जो केस था वो इरिगेशन से रिलेटेड प्रोजेक्ट के बारे में था. सो यहाँ पर हाई कोर्ट ने उस कंपनसेशन को 1 लाख से डिक्रीज करके 50,000 किया गया था. सो दैट वॉज not right. That was mentioned in this particular case by the apex court, that this is not right because the estoppel principle will be applied over here and amount of compensation cannot be changed later on because as it was decided in the contract, the parties are estopped by it. Another very important case, I would say, इस केस को क्यों इतना इम्पोर्टेंस दिया गया है, बिकॉज ये सिविल लॉ में तो इम्पोर्टेंट है ही, एंड देयर वाज अ स्प्लिट ऑफ ओपिनियन ऑफ द जजेस इन दिस पर्टिकुलर केस. यू शुड नोट दिस. मनिक मजुमदार एंड अदर्स वर्सेस दीपक कुमार साहा थ्रू देयर LRs 13th of January 2023. In this case, presumption was another important topic that was discussed. Evidence Act section 85, presumption as to powers of attorney. Powers of attorney, there is a presumption in favor of that. Then proof of signature and handwriting of persons who have signed or written that document which is produced before the court, that is section 67 of Evidence Act. And correlation with Registration Act section 33(1)(c). So this was being considered in this particular case. I suggest that you should go through the details of this judgment. It is a very landmark one. There was a split of opinion. One of the judge was in the respected judge was in the favor of power of attorney, and that it is a valid one, and another judge was not in its favor, and was one judge who was in favor of the power of attorney judgment was in favor of the presumption provision of the Evidence Act was being discussed. Presumption in favor of a 30-year-old document is a rebutable presumption. So unless and until it is rebuted by sufficient evidence by the opposite party, it can be relied upon. This was the view. This was a lenient view, and as a matter of fact, the parties should act upon the terms of the said document. 1963 का वो डॉक्यूमेंट था. So the trial court was right in upholding that particular document to be a genuine one. It was held that it was authoritatively laid down by this court that a registered document carries its own value and presumption also in favor of it. Next is a High Court judgment that is worth discussing over here. That is Pappu Bavaria and others versus District Collector, Civil Station and others. In this particular, relating to child labor, a judgment was being discussed. Kerala High Court had ordered the release of 2 children from Delhi who were sent to a shelter home, alleging that they were being forced into child labor by selling articles on the streets to the custody of their parents. So they were sent back to the custody of their parents by the order of the court in this particular judgment. Why this was done? As per the law, that is Juvenile Justice Act, Section 2, Clause 14, what is the ruling? That they should be sent in the juvenile care homes. And Kerala High Court, on the petition of the filed on behalf of the parents of that child, has restored his custody back to his parents, because selling of articles was not recognized as actually being a very something which is very laborious. Selling of small articles was accepted because he is supporting his family. He is doing that out of the financial need that his family requires. So at that time, keeping equity principles in mind, the Kerala High Court has made this judgment and restored the custody of the child to the family. As a result of primary responsibility of care rests with the biological family. This was held in this particular judgment. Another important interesting judgment of the Bombay High Court bench at Aurangabad, that was passed on 7th of January, Rushali Jayesh Kore versus State of Maharashtra and others. This particular judgment, it was relating to FIR that was filed. That FIR was filed and it was actually a result of the misuse of powers. There was a matrimonial dispute existing which extended to that much that it dragged the person who was charged with the FIR. He was a judicial officer. There are certain facts of the case. It's very interesting. You can go through the case facts in detail. So the charges that were levied against him were 323, 504, 506 and so on, along with 34 of IPC. Dowry sections were also there. So quashing of FIR was sought, and in exercising the power under section 482, High Court has quashed this particular FIR, holding that the right to reputation and dignity of an individual is integral part of Article 21 of the Constitution, and misuse of matrimonial disputes 498A का extension इसे माना गया that the husband's brother he was dragged into this particular case. So this was taken cognizance by the Hon'ble High Court in this particular case, and this is another important judgment of this particular year within the 15 days. I hope this information was very helpful for you. Please you can take note of all the judgments, and if you are having any queries, do contact us in the comment section of this video as well, and stay updated with iExamBee. Prepare 50% faster for all your examinations. Thank you so much.